Welcome back to the channel. I really appreciate you coming in and watching. I am trying to wind down this series, so hopefully we're fairly close to it. In this episode, I'm going to talk about trusts. I have opinions with regard to trust that seem to run contrary to a lot of the other voices out there. And typically, when I have folks in the office and I explain them, that it makes a lot of sense. So I'm going to take this episode and explain what I have been alluding to most through this series, which is trust and my perspective on trusts. So I get the question all the time of people coming in saying, I'm going to trust. My first response to that is always, why? What is it that you don't trust? Because that's really where they fit in. A trust is about who or what you don't trust. There are states that no one trusts the probate process. There are built-in expenses and delays and that sort of thing. And so in those states, which are typically the bluer states, a lot of the states that people are moving to Tennessee from, reminder, I'm a Tennessee attorney. I'm not trying to practice law anywhere else. But they'll all come in with their trust because in those states they don't trust the probate process. So that's a part of it. Do you trust the probate process in Tennessee? The probate process is pretty easy, pretty affordable. You know, if somebody comes in and just says, well, I want to trust because I don't like the probate process, we have a talk because typically they've been reading the Google too much. They've been reading the Google about horror stories from other states and not Tennessee. Now, if you've got family members that are going to cause drama or going to cause problems, that's a reason for at least a very well-worded will. You may not need a trust just for that, but it's a reason to consider it. So when it comes to trust in my practice, typically we see a revocable living trust. They're nice, easy, and flexible. We see testamentary trust. I put those in all of my wills. So on that level, I'm always using trust. But remember, those don't spring into life until the judge says that they're valid. But then also special needs trust. I love special needs trust because in those situations, what we're doing is we're maximizing people's benefits. The trust I get asked a lot about that I rarely ever do is what's called the irrevocable living trust. And we'll talk about that in a minute. So just real quick, a revocable living trust is a nice, easy, flexible document. It works because there's a statute that says it works. That's the only way that comes about is there's a statute that says that you can have a trust, which is a legal document, a legal piece of paper that you title things into, and it effectively works like a beneficiary form for those things. So I really like those whenever we're dealing with a husband and wife, or a parent with minor children. It doesn't have to be husband and wife. That maybe they've got large life insurance proceeds, retirement account proceeds, that sort of thing, and we're dealing with minor children, and a trust is a really good basket to catch those. We don't want it to own them. Trust can be taxed pretty hard, and I'm not going to get into the trust taxation, in this episode, but just understand that trusts get to high tax brackets really, really quick. That's why typically you don't want them owning accounts that should make some decent money, but the trust is a good target, a good recipient in case it needs to be controlled for a younger child or somebody who has special needs and that sort of thing. So that's where I see most of my trust work is with the revocable living trust. They're very easy to change, even if you move states. Remember, state and probate law is very state specific, but if you move states, they are very workable. So I really like them. So that's what I see mostly with my practice, are revocable living trust. Now, like I said, in every one of my wills, I do a testamentary trust, and again, it's to catch those items that would go to a younger person. Typically, in my experience, 18 is not necessarily the best age for somebody to get large sums of money. So maybe we draw that out a bit, maybe age 25, something like that. That's a lot of what I see. But a testamentary trust is not its own standalone document. You're not necessarily going to title things into it because it's not its own document. It springs to life whenever a probate judge says that it has their blessing. So just understand it's not it's not as quite as functional as the revocable living trust, because the revocable living trust stands on its own, doesn't need a probate judge blessing. So that's the nice benefit there. Then when we talk about a special needs trust, that has everything to do with preserving somebody's benefits, maybe even preserving them. I mean, I've had the case before where, somebody got in a big injury settlement, and the funeral was not long after that because they just couldn't handle it. So if you've got that situation, that's where that special needs issue comes in. But again, like I said earlier, trust is all about who or what you don't trust. Now, when people come in and they're asking about what's called the irrevocable trust, or they may refer to it as the Medicaid Asset Protection Trust, in those instances, they don't trust Medicaid. The problem I have is that Medicaid's the goal, and I don't ever think Medicaid should be the goal. Medicaid is for poor people and also people who just really didn't plan all that well. I just don't think that being on a government program should ever be the goal. I think we should use all the assets that we have, including the old house, to be able to live well. It's like part of my slogan, living well and being remembered as the hero you already are. I want them to be able to live as well as they can. And honestly, I don't remember if I've mentioned it in this series or not, but I grew up working in nursing homes and assisted living centers. I've done this. I've been in janitorial. I've been in the kitchen. So I've seen it. I've seen what it means for people to rally all of their resources, and there's some really good financial tools these days. Rally their resources and live well, and then I've seen what it looked like for somebody who was just living where the government told them to go. So I just don't think that's a plan. Every now and then there's a good case for an irrevocable trust to try to save things from Medicaid, but at the end of the day, I just don't think that should be the goal. I know law firms who are just all sold out on that, and that's who I refer people to. But for the average person, when I'm doing a trust, it's going to be a revocable living trust. It's going to be flexible. It doesn't carry the same Medicaid asset protections. But again, that's not my thing. Where I do like trust, especially, is where we're protecting the beneficiaries. So maybe it's a beneficiary's creditor that we don't trust. Well, whenever we pass away, we go into our reward. Those things that we put in trust are protected from our beneficiaries' creditors. Not necessarily our own. If we leave a mess behind, we're not necessarily going to have protection from that. But for the purposes of our beneficiaries, if they've made a mess, assets that we put in trust can be protected for them. So, and really, I think the last thing to kind of wrap this up is you will see fairly regularly the advertisements that say will or trust. Well, generally those folks aren't law firms, and they don't need to be practicing law without a license. But that's not a very good question. Will or trust? You always, 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 always want a will, because if something doesn't get into the trust, and I've seen that, if something doesn't get into the trust, you want the will. If you choose to take that extra level of planning and protection and have a trust, fantastic. Don't think it's going to solve everything. If you don't put any assets into it, it may be entirely ineffective. Trust handle what you put in them really, really well. They handle what you title into them really, really well. They handle what, depending on your state and the statute, whether or not you put personal property in there, they handle that really well. But they don't handle everything. And so from time to time, you'll see situations where somebody's passed away. They've had a lot of stuff over here in the trust, but they didn't get everything into it because they didn't look at monies that they had coming in, or maybe they just had a situation where they just simply couldn't have avoided it. And in that case, they need a will. So I hope that you have found this helpful. I believe this is going to wrap up the series, but if not, you'll see it because it'll be the next one on the YouTube channel. But if I don't see you again in this series, I hope it's been a blessing. I hope that you can leave a legacy of peace, not a legacy of chaos. Remember, again, my name is Zale. I'm a Tennessee attorney. I'm not trying to practice law in any other state. I have other licenses, but this entire series has really been built around my law license. So I help people to live well and to be remembered as the heroes that they already are. And I will see you in the next series. Thanks for joining in.